Hello friends, today we're going to continue with part 2 of our 3-part series relating to the factors that a court will consider when determining a parenting plan and time sharing schedule. What a court kind of thinks about when it tries to figure out how much time to give to each parent. So welcome back to the Divorce Broadcast. My name is Manny Segarra, coming to you from Miami, Florida. All right, so continuing on our momentum and previous discussion about the different factors under 61.13, we're going to go right into it with the next factor, which is the mental and physical health of the parties. Remember, we're not talking about a little boo-boo, like you stubbed your finger or you got a paper cut, you're a little bit sad today and you woke up on the wrong side of the bed, or you're a little down in the dumps. We're talking about serious, significant stuff. So let's take it in order, starting with a severe chronic illness, such as cancer, MS, or severe diabetes that may have an impact on their ability to take care of the children. Same thing with physical disabilities that limit either a parent's mobility or their ability to perform essential parenting tasks. Now, this doesn't mean that if you have some sort of physical disability that you can't be a great parent. I have seen parents that had limitations, like a parent that was blind or a parent that is confined to a wheelchair, be amazing parents. But this is definitely a factor that a court will consider. Now that we've touched upon the physical side, let's talk about the mental health side, which is just as important. There are some mental health conditions that can manifest and possibly affect a person's ability to be a parent. Examples may include severe depression or severe anxiety, bipolar disorder, any type of engagement in physical or self-harm. There are other severe mental health issues like schizophrenia that may raise a concern by the court as to whether or not this parent can effectively parent the children. So if that is happening, it is so important to get help. In addition to this, on a more limited and temporary basis, there may be some concerns regarding infectious diseases. For example, during the COVID pandemic, there were some motions that would be filed back and forth. Also, if some sort of injury or surgery comes up, this is something that a court would also consider on a temporary basis. Up next is the home, school, and community record of the child. This is important. I think that courts like to keep this consistent. So the courts will always consider where the child or children have traditionally been enrolled and what grade are the children going into. Is it a transition year, like 8th grade going into high school, or is it a year kind of in the middle so that a transition wouldn't be as abrupt for the child? When selecting a school, the parents should always try to communicate and try to co-parent and jointly make these decisions. It's important for the parents to look at the educational philosophy of the different schools, the academic quality of the schools, if historically the children have performed well there. The class size and the student-teacher ratio is also an important consideration. Location is a huge consideration. The parents should really try to discuss the location of the school and get it ideally somewhere that's in a midpoint location between the two of them. If both of them live in the same neighborhood, it is so much easier. The parents should also consider the safety and discipline style of the school. Make sure that they research how the school approaches disciplinary process. Extracurricular activities are huge. If the child has special needs, then it's important to make sure that there are special education services available at that school. Also important is technology and resources. You want to make sure that you get information about the science lab, computer lab, and what are some of the technology requirements of the students. The cost of the school is also important. Remember, Florida law does not require you to send a child to private school, but if there is a special circumstance, either special needs or it has historically happened, the court may order private schooling, so we need to see what's in the best interest of the children. Diversity and inclusion is also a big selling point for a lot of parents. And finally, transportation. Is there a bus that is able to make it close to the home of each parent, or is one of the parents at a disadvantage because they have to drive a significant amount of time in traffic? These are all considerations that must be discussed when the court determines the time sharing schedule. The next factor is a controversial one, and that is the reasonable preference of the child or children. If the court deems the child to be of sufficient intelligence, understanding, and experience to express a preference. In other words, the choice or the preference of the child as to where they should stay. And that's a tough one. A lot of times that this causes a lot of anxiety for the child if they are required to either testify, speak with the court, or speak with a guardian ad litem so that the guardian can tell the court what the child wants. This is really tough on the child and may require counseling afterwards to help them deal with this type of stress and anxiety if that's the case. While the child's preference may be considered by the court, it must, and that means it has to, align with what the court believes is in the best interest of the child. So children don't always get what they want. When it comes to how much weight a court will give the preference of the child, in my experience, I have found that the older and more mature that the children are, the more likely the court is going to consider and go with their preference. I've seen some younger children that are very mature, and I've seen some older children and teenagers that are a little bit immature. So a court will really look at that. There may also be special circumstances. If a child has a specific reason that they want to be with the other parent, so some sort of strong attachment, or the concern that the other parent may not be able to provide a stable environment, or there may be domestic violence, a court will really consider that type of testimony. Remember that a guardian ad litem and a custody evaluator sometimes will be appointed, and a court will give a lot of deference to what these professionals report back to the court is the child's preference in terms of custody. One of the issues that the court will always also be very attuned to is if there was any coercion or duress placed on the child. I've seen it happen before where there's a court hearing in which the court is going to hear the testimony of a child, and one of the parents either tries to coerce the child by either intimidation or threats or making them feel bad. I've seen a situation in which one of the parents promised to buy the child a puppy dog in exchange for them to testify favorably in front of the court. So this is a very delicate and complicated area of the law, and something that is definitely in play when a court determines a parenting plan and time-sharing schedule. The next factor is the demonstrated knowledge, capacity, and disposition of each parent to be informed of the circumstances of the minor child, including, but not limited to, the child's friends, teachers, medical care providers, daily activities, and favorite things. In other words, don't walk into court not knowing anything about your kid, because you're going to get asked by that. So we'll go over why this is important. When it comes to knowing about your children's friends, friends are so important because oftentimes children rely upon their friends for emotional support during challenging times like a divorce. Also, understanding who your children's friends are allows parents to facilitate and encourage these relationships, which can help children cope with some of these difficulties. You can also check out their peer influence. If their peers are good students, they abide by the rules, that's wonderful. If they're in the wrong crowd and they like to either engage in gang violence, recreational drug use, or alcohol, that may not be the choice of peers that you want your children to be involved in. Parents have a better understanding of the possible influences on their children's decision-making process, their behavior, and their emotional well-being. Remember that parents can be friends with the other parents of their children's friends so that you can have a network and support. Parents can engage or set up play dates or social events and make them feel a lot better and a lot more comfortable. By doing all of this, when a parent goes to court and they're questioned about it, they are aware of the intricacies of their children's relationship with their friends. It is also extremely important to know about a child's teachers when you're stepping into court. Understanding who your child's teachers are allows you to establish a positive and supportive relationship with the teacher and staff. This can be especially important if your child needs additional educational support or resources. Teachers can provide you with valuable insight into your child's academic progress and any areas that they may need improvement, and you want to be active in those areas. They can also act as intermediaries with your soon-to-be ex-spouse. Also, teachers are usually one of the first to notice any changes in a child's behavior or emotional well-being. A lot of times they'll get reports from class that the child is misbehaving or that their grades are slipping. This may be a great cue that the divorce is having a negative effect on the children. Making sure to attend parent-teacher conferences is huge. If a parent shows up to court and they are asked, when was the last time you went to a parent-teacher conference? Or have you ever met the teacher? And the answer is no, that parent is going to look really bad in court because the judge is going to be sitting there looking at them like, you want me to give you how much time with your kid and you haven't even taken the time to meet their teachers? It looks awful. It is just as important to be involved with your children's medical providers. Staying informed about your children's medical providers, such as pediatricians and specialists, ensure that you can maintain the children's continuity of healthcare and address any health concerns. In the event of an emergency situation, you have all of that information already at your disposal. It also helps with health insurance coverage. A lot of times, if you are aware of the providers and you know where the doctors are or who the specialists are, it helps you navigate that process so you're able to get either reimbursed quicker or approved quicker for these types of issues, and especially if your children have special needs or chronic conditions. You will look really, really bad in court if your child has these special needs and you've never been to the doctor with your child in your life. So make sure that you stay on top of the medical providers. The next factor is the demonstrated capacity and disposition of each parent to provide a consistent routine for the child, such as discipline and daily schedules for homework, meals, and bedtime. I will tell you, consistency is king. The courts love consistency for the children because they know that that is only beneficial for kids. I'm going to give you some examples of bad consistencies for the children. This includes inadequate morning or evening bedtime routines. This means that when everyone wakes up at the last minute and it's a mad rush to get out the house and the kid doesn't even have breakfast, or at night when there's no rules as to when the children can go to bed, especially for the little ones because they need a little bit more sleep. Unpredictable meal times. Children, again, they need routine, so if there's no guarantees that dinner is going to be at a certain time, maybe they don't eat dinner consistently, or maybe they go to bed hungry. A lack of homework structure. It is important for the children to have a space in the house, that way they can do their homework. One of the other problems is either unplanned screen time, which means that the children will stay on their phones or on their computers for too long of a time. Another big one would be the lack of chores or responsibilities. By having chores around the house, children learn that they have to pitch in, they learn discipline. You don't have to make them take out the garbage every day, but it would be helpful for them to have to clean their rooms, pick up after themselves, and then have any additional chores. Maybe there's a pet, maybe they can help feed the pet and things like that. Another example is inconsistent rules and discipline, when the children don't understand when there are consequences to their actions. Changes in caregivers, that may cause a disruption in the children's life. And finally, an irregular attendance at an extracurricular activity. That doesn't show a solid routine for the children to thrive in. Having a consistent routine is often preferred by the divorce court because it enables the children to have a sense of a stable and predictable daily life. It also provides emotional security. It gives them a sense of safety and comfort in the homes and the lives that they live in. It reduces stress. A consistent routine helps the children minimize unexpected and unfamiliar situations so that they are able to manage their day-to-day better. It also improves their sleep, which in turn promotes children to have more physical strength and well-being. Studies have shown that proper sleep contributes to an improved mood, attention, and cognitive functioning. Discipline is also a big issue because a routine encourages children to take responsibility for their actions, and it also improves in the behavior of the children, as that there are clear behavioral expectations for the child in a routine when it's stable. So these are all the benefits of why courts like when one parent can establish a routine for the children. And now we've come to the final factor that we're going to cover in the second part of our three-part series on the timesharing factors under Florida Statute 61.13, and that is the demonstrated capacity of each parent to communicate with and keep the other parent informed of the issues and activities regarding the minor child, and the willingness of each parent to adopt a unified front on all major issues issues dealing with the child. This is huge. It is both parents being on the same page with the children. And as I just did with the other factor, we're going to go over some examples of bad communication between the parents. Starting out with the issue of withholding important information about the child's school events, medical appointments, or extracurricular activities. Let's say there was a recital and one parent didn't tell the other parent, or let's say that the child was in the emergency room and the other parent doesn't find out. All this is bad. High conflict conversations, when the communication between the parents is marked by hostility and frequent arguments, especially when it's in front of the children. Another example of bad communication is a failure to notify about changes. Maybe they change the religion that they now are exposing the child to, or maybe they change the tutor, or maybe they change the medical regimen. These are all examples of bad communication. And then inadequate involvement in decision making, when one parent unilaterally makes decisions about the child or children without informing the other parent about this important situation. Now that we went over some of the bad ways that parents communicate, I would be remiss if I didn't try to end this video on a positive note and talk about the good. When good parents communicate well, starting with coordinated scheduling. When the parents agree to a clear time-sharing custody schedule and they abide by it. Everyone is reasonable. If a little change has to be made, or if someone wants to sleep over at their friend's house, one of the kids, and it's okay. That is wonderful. Consistent rules and expectations across both households. Examples may be when homework routines are the same at both households and when the discipline methods are the same. This is exceptional communication, and these parents should be proud of themselves. Also, open communication, when the parents can communicate about the issues involving the children's needs, concerns, and achievements. They share information. They're not trying to hide the ball from anybody. Another great example is coordinated special occasions, when the birthday parties can be together or the holidays can be shared. Maybe they split the holiday in half. For example, for Christmas, maybe someone does Christmas Eve until Christmas morning and the other parent does Christmas Day. That is a beautiful thing. Support for the children's relationship with the other parent. The coordination of expenses. This is oftentimes a fight. One parent will incur an expense and then the other parent doesn't reimburse them. Well, don't do that. If a parent incurs an expense for the child, it is incumbent upon the other parent to pay them back as soon as possible. That shows a lot of good faith and goodwill. Adding to this is having an amicable relationship. It is a beautiful thing when the parents run into each other in front of the child and they're amicable. They're able to say hi. They have a warm smile instead of fighting. So at the end of the day, the best pro tip that I can give you in this particular section is get along. Your kids love you both. You're both equal to them in their eyes. So don't lose sight of that. Try to get along as much as possible if you can. All right, so that's a wrap on part 2 of our 3-part series involving the different factors under Florida Statute 61.13 that a court will consider here in Florida when determining a parenting plan and time-sharing schedule. If you know anyone that might find this information useful, have them look us up at www.segarralawfirm.com. We have offices in Miami and Orlando, Florida. Se habla español. Do us a favor and like this video. Subscribe to the Divorce Broadcast. Drop us some comments so that we can get back to you. And remember, parents, let's all get along. It'll make your children a lot happier. We'll see you next time.